button now. So yes, welcome today. Thank you all for your interest in joining on this hot Wednesday morning to discuss a matter that will have an impact on both on businesses in Norway and also on Latvian exporters that are operating in the Norwegian market. And namely, we will be talking about the Transparency Act, which will come into effect this upcoming 1st of July. So for today's program, today the event is organized together by Norwegian Chamber of Commerce in Latvia, together with the Latvian wood construction cluster and Codex Advokat law firm, the first climate neutral law firm in the world, as they'll be able to tell it themselves. Before we go into some in the substance, I would like to invite Kristaps Ceplis from Latvian Wood Construction Cluster to give a few welcome words as well.
Hello, everyone. I'm very happy that so many people are coming today and joining us in this seminar. So, as you know, as we know, that Norway is a very important market for Latvian wood construction companies, and that's why we are having quite a very good relation with the Norwegian Chamber of Commerce in Latvia. So, and we were looking for some special things, special law and acts what's happening in Norway. So that's why altogether we decided that we need to have this kind of seminar to just for our producers, for our companies who are working on Norway market or maybe who are planning to do this, just to be informed what they have to know and what's happening. So I'm very happy that we are here and I hope that the information we're going to get so going to help us in the future. Thank you.
Thank you very much, Kristaps. I've also informed the speakers that we have not only the wood construction companies joining us today, but also other manufacturers and service companies who really want to understand what's this new regulation is about. So as for today's program, it will consist of 3 parts. First, we'll have a presentation by Codex Advokat, attorney at law and partner Petter Sverstad Eriksen, and Associate Partner Tine Granlund, who will explain what is the Transparency Act and what implications it will have on the Latvian exporters. And we are also delighted to have Pål Arne Davidsen from Rud Pedersen Public Affairs, who will also give a perspective from the public affairs perspective on the new developments. So without further ado, I would like to give the floor to Petter and Tine, and if we need to, yes. So we have the screen up, and so yes, I'll hand over the microphone to you. But before, a few housekeeping rules. So let's keep the microphones other than for the speakers off during the duration of the webinar. If you have any questions, please post them in the chat or raise your virtual hand, which you find in the lower bar. So yes, now we can proceed. So Petter and Tine, the floor is yours.
Okay, thank you, Ilse. I hope that you can hear me, everyone, now. It's a warm morning here in Oslo as well. It's bathing in sun, which is nice. I hope it's like that in Riga and Latvia as well. What we're going to do is that we're going to give you, as you said, Ilse, a short introduction to the Transparency Act, which comes into effect now on Friday. Just to give you a short overview first, we have quite a lot of slides, but what we were thinking is that you are sure to send out the slides after the seminar, or usually you do that. So we thought that it's best that we include a lot of information, and if we don't get through all the slides while we're talking, we think that that's not really the problem. We'll try to focus on the main ones, and then you have additional information on the slides that you receive. You introduced us. This is my colleague, Tine, who is head of Codex Green, which is our internal group, which focuses on being at the front of the sustainability movement when it comes to what does sustainability and social governance within corporations mean for our clients legally. So that's sort of the space that we've been taking in Norway. And she's the expert on the Transparency Act, and I'll try to substitute where I can. As you see, the title of our presentation is the Transparency Act. What does it mean for Norwegian and Latvian businesses? But of course, what does it mean for foreign businesses as a whole as well? So Tina, I will let you start.
Thank you. I'll try to give you a general overview of the regulations in the law. And as Petter said, a lot more details are available in the presentation, so you can read more details later if you want. This is a new law, both in Norway, but also in Europe, so that we don't have a lot of praxis as for now. So one have to monitor the development in this legal area as time passes on. As Petter said, Friday is the date. As we experience, a lot of Norwegian businesses hasn't started doing these due diligence assets as for now, but our main focus is now to tell businesses to start. And what you should start with, I will now give you an introduction to. I was hoping I would. Sorry. We're having a bit of technical struggles here in Oslo today.
Yeah. Just short, who are we? Ilse said it, we're the first climate neutral legal firm in the world. And what does that mean? We don't produce anything, at least not physically, and we don't use a lot of machinery. But what we did is we did what we could, and we started to affect everything we did in our daily work. What kind of sort of paper do we use? What do we do with the food that's left over? We are situated on top of the on the subway here in Oslo, and so forth. Just a short also introduction. We are a full service firm for corporations. We do M&A and corporate, technology, IPR, employment law, which is very important for a lot of construction companies, building and construction, compliance, commercial contracts, etc.
Thank you. Over to the Transparency Act. What is it and what does it comply businesses to do? It is the duty to carry out due diligence for basic human rights and decent working conditions. It was adopted by the Norwegian Storting on the 9th of June last year, and it is, as said, effective from July 1st, 2022. And as I said, it is time to start working on carrying out and documenting due diligence related to human rights and decent working conditions in businesses.
Yeah, right here you can see there's a lot of attention right now. Just to give an introduction to the Norwegian media landscape. On the left-hand side there, you can see one of the largest regional newspapers on the western part of Norway saying that we have to enforce the law from day one. And this is a commentary to the supervisory authority that has said that they want to monitor first and they will not start sanctioning immediately, but they will try to negotiate and help people find their way. So I think what's most important about this slide is that it shows that the Norwegian media and the Norwegian government watchdog for consumers are really ready to start investigating companies to see if you are complying with these regulations.
As you can see, the Transparency Act, Section 1 says that the Act shall promote enterprises' respect for fundamental human rights and decent working conditions in connection with the production of goods and the provision of services to ensure the general public access to information regarding how enterprises address adverse impacts on fundamental human rights and decent working conditions. I will come back to the impact this formulation has for the companies, But as for now, we will take a closer look to the definitions. This follows in section 2. What does human rights relate to? What does it mean? It's the international recognized human rights. It is the opportunity for anyone to earn their livelihood through work, and that he or she has free chosen or accepted work. Also, fair wages and equal pay are something that you in these due diligence processes look for in the businesses. Related to decent working conditions, that is work that safeguards fundamental health, safety, and the environment, and the work that gives salary to live on.
And I can add that as the companies who already operate in Norway know the standard that the Norwegian watchdogs apply to these sort of recognized human rights, work safeguards, health safety is quite high, and this will be seen with Norwegian eyes. So you have to adapt to the region as well. I don't think you can have a generic definition of good working conditions. I think that that's okay. It will be good working conditions seen with Norwegian authorities' eyes.
Good point, Petter. And a central question, who is covered by the law? In Norway, approximately 8,830 enterprises will be covered directly. These are, roughly said, large enterprises defined by the Accounting Act. But the Act applies regardless of the form of organization. Let's see here. What large enterprises are defined as enterprises that are either covered by the section 1.5 in the Accounting Act or on the balance sheet date meet 2 of the following 3 criteria. The sales revenue over 70 million Norwegian kroner, a balance sheet over 35 million kroner, or the average number of employees over 50 full-time employees. So if you meet 2 out of 3 of these criteria, you are directly covered by the law. But there is also extra interesting view regarding who is indirectly covered. I will come back to that. As you see, the parent companies shall be considered larger enterprises if the conditions are met for the parent company and subsidiaries as a whole. So you have to make assessment of the whole. Related, as Petter said, foreign companies, are you covered by the law? It follows in section 2. The Act also applies to larger foreign enterprises that offer goods and services in Norway and are liable to tax to Norway pursuant to international Norwegian legislation.
So, and larger foreign companies or enterprises, that is as defined on the previous slide.
Yeah. But as I said, smaller enterprises will also, in a larger scale, be covered indirectly and specifically through contractual obligations. We see through our clients that a large number of contracts now impose duties of due diligence through the contractual chain for their suppliers and sub-suppliers. So even if you don't meet 2 out of 3 criteria, your contractual obligations can enforce you to comply with the Transparency Act.
Our estimate is that, or what we're seeing is that companies will be afraid not to comply with the Act. So yeah, they will put into their contractual obligations, that they put into their contractual chain, that everyone from top to bottom shall comply with this Act. We also see that even though public companies, such as local counties, etc., are not directly covered, these will want to show that they take this seriously, and they will either demand the compliance from contractors that are not directly covered by the law, but they will demand it nonetheless, or they will demand that the big contractors comply throughout their supply chain. So really what we're saying is that this will integrate into all contracts in Norway. Yeah.
As you were in now, the Transparency Act in procurement practice, even though a lot of official Norwegian institutes are not directly needed to comply, in the contractual area or in public procurements, a lot of these criteria in the Transparency Act will be relevant. I think I will leave it to that.
Yeah.
You can read, for those of you this is important too, you can see a lot more details here. But I think we will leave it to that. And the goal is that it will be easy to uncover misconduct because you are obligated to report on human rights and basic working conditions.
I can just add that the reason why we have included this is because government building projects and government projects in general make up a lot of the Norwegian economy at this time, because the government put into effect special stimulus packages during the pandemic, so that even though this is something that you need to comply with, it also represents, or should represent, a very good business opportunity for a lot of companies in the Baltics.
We're moving on to what are the consequences of the Transparency Act. Will you say something about this?
Yeah,
Petter?
as we said earlier, the watchdog has said that they will try to guide companies starting from July 1st. But as we know, if the media pressure becomes strong enough, then someone will feel the need to do something. And what can they do? Well, in the Act, it is stated that non-compliance will have the impact that you could have infringement fees. And as we've seen in competition law, the infringement fees are quite large. And we do not know what the infringement fees will be like here, but there are people calling for them to be quite large, quite substantial. So nobody wants to be the guinea pig, and certainly you do not. It is expected that you will have also a serious negative impact if you are dragged out in front of the media as not complying. And it also means, we think, that if you are in compliance, you will have a good position to be competitive when suppliers are being vetted. So we tend to regard this as a possibility for increasing your competitiveness and your desirability in the market, rather than something negative.
As you can see, the Transparency Act, you can divide into two. It's the requirement for due diligence assessment, both in your own company, but also in your contractual chain. But it's also the duty to provide information related to these due diligence assessments. What does a due diligence assessment mean? First of all, it applies to the entire supply chain. It is the duty to investigate and assess a risk associated with human rights violations and decent working conditions. It is also the requirement to implement risk-reducing measures based on the assessments you previously have made. And it is the prioritization, yes, of risk based on the severity and impact of possible breaches. The assessments will differ in both content and scope, but it is to be performed regularly. So you can't just do these assessments once, you have to follow up regularly to be compliant with the Transparency Act. But it shall be in relation to the size and nature of the enterprise. The bigger enterprise, possibly the more pressure on being compliant. But as Petter said, the watchdog, the practice and the size of the potential fines are not
clear yet. No.
Thank you, Petter.
But also, as we can say already, is that we think that the way to start is to not get overwhelmed, but to just have a plan. Start with the small things, and we believe. Of course, we can't guarantee, but we believe that if you show that you try to be in compliance, that you are striving to fulfill these demands, then the watchdog and the media and the public at large will be satisfied. Because we're getting to that, but the public at large, anyone will be able to send a company a request for information, and you have to have a package of information ready and deliver it to them. And we also expect that a lot of the Norwegian media already have lists, and on July 3rd or 4th, they will start sending out these requests to companies. But we believe those will be the larger companies that are at risk in the beginning. Yeah.
And from the date that you get provide of information, you have 3 weeks to give the information. So you don't have to do it right away, but 3 weeks go by fast. So thereof are you have to start now.
Yes, and once again, nothing to panic about. Just start slow, and we, as many others, have made checklists, and we are ready to supply you with what you need to start this work. So this can be done in a slow, easy, and orderly manner. But again, we have to start.
We will give you some practical tips on where and how you can start in the following. But I can say that the Transparency Act is supplemented by the OECD's Guide for Due Diligence for Responsible Businesses. I will give you some examples, and we will also use examples when we go through what the due diligence assessments are. The OECD sector guidance have 5 different sector guidance. For building and construction, there is no sector guide yet. But however, many of these will give you a relevant information, or you will use them to see types of evaluations done. You can also look to these for concrete examples on what is required. As an example, shoes and textile sector guide. You can see in this that a large part of the workforce in the supply chain consists of women, and that women are more vulnerable for negative effects, such as, example, lower wages, unsafe working conditions, and sexual harassment in the workplace. This is a place to start in the due diligence assessments, and where to look for possible breaches and in your risk evaluation to consider. It is a general recommendation that in the due diligence assessments, one should focus on women in all levels related to the risk as mentioned just now. The due diligence assessment consists of 6 steps related to the section 4 in the Transparency Act. This is in Norwegian, but as you can see, the wheel consists of the 6 different steps. And as you can see, the wheel goes on and on. As said, this is not something you do just once. You have to continue to do it as long as the Transparency Act is related to the business. But we evaluate that the work related to the assessment will be largest the first time. And if you have new suppliers or new merchandise, you need to do a new assessment related to that concrete buyer, for example. But in the first time, you need to go on a broader assessment.
As with all things, it's hardest and it's most annoying the first time that you have to do it, because you have to learn it. And we estimate that this will become second nature in a couple of years, and also that the level of work that you have to put into it will decrease as it is professionalized also by a lot of advisors, so that you can get assistance. And
also, as we moving forward, we'll have more best practice from the watchdog Forbrukertilsynet, so that you can see how one more efficiently are compliant with the Transparency Act. You can see the 6 steps. I will just go generally through this now, and in the following pages you will have more details. I will not go through all of those, but if you have questions after today's webinar, please just send us an email related to these 6 steps. But the first step is to anchor accountability in guidelines and management systems in the business. It is secondary to map and assess actual and potential negative impacts related to your company's business, product, or services. It is thirdly to stop, prevent, or reduce negative impact damage related to the mapping and assessing you did in step 2. It is to monitor the implementation and results from step 3, and it is to communicate how the impact is handled, and it is point 6 to ensure or cooperate on recovery and complaints arrangements where required. So you can see that it is a wheel. You have to do this ongoing.
I think that for most companies, they will just incorporate this into their compliance routines and their governance routines, so that it becomes a part of what you already do as part of your corporate governance.
And we see that a lot of companies already have systems that are almost compliant. So it is the main focus on the job is to gather the information and put it in a report that is compliant with the Transparency Act. As Petter said, step 1 to anchor accountability and guidelines is to create specific policies for the company's most significant risks. And a lot of companies already have this in place. So you have to assess, is what we have enough to be compliant with the Transparency Act? You see the steps on the left side, and on the right side you see examples based on the OECD guidelines on how to be compliant with the different steps. I will not go through all of those, but they will give you a good indication of what you can do to be compliant with the different steps. Step 2 is to map and assess. This is the due diligence part of the Transparency Act. You should also, for example, work out routines for assessing risk in supply links further down the chain. If you have a new supplier or business partner, you should have a routine on how to assess risk related to that contractual cooperation. Step 3, here are examples on how to stop, prevent, or reduce the negative impact or potential negative impact that you previously discovered. And step 4 is to also monitor the implementation and results. So even if you find risk and you do stop or try to decrease, you also have to monitor the actual things that you do to increase the risk. An example on how to is a third-party assessment. We have some clients that wish that we are the third-party assessment, and that we do that every, for example, 6 months. That's one way to be compliant with the step 4 on how to monitor results. Step 5 is the actual report on when you communicate how the impact is handled. Here is how you do it. It is externally reported through the company's annual report on sustainability, and it is to be published on the corporate's website.
It shows that not only do you have to do this internally, you have to also expressly report externally and show that you are taking measures.
It is to be transparent on how the business handles these type of risks related to possible breaches of human rights. It is to ensure or cooperate on recovery and complaints arranged where required. Here are some examples on how step 6 could be handled. But as we saw earlier, the due diligence assessments are one thing, but the reporting obligation is also a factor you have to have in mind. We were in that you shall publish an account of the due diligence, and the statement must be updated and published by June 30th each year, so that this year you don't have to publish a report, but June 30th next year, the directly applied companies have to have their reports ready. But in addition, you also have to frequently answer out any direct questions you receive in the middle period.
So I would think that what is practically most important for Latvian companies or foreign companies is to one, find out are you directly affected by this, and two, if you are not, then please go through your contract agreements and see are we, and this is perhaps not that important yet, but at least from July 1st, are we required to do any of this reporting? And three, when you enter into agreements with Norwegian companies, be aware that there might be reporting requirements in the contract, and try to assess if these are just copy-paste or if it is something that you might negotiate with this larger entity or this Norwegian entity to assimilate how you report relating to how big, for instance, your contract is. Is this really something that you need to do if you just simply deliver, just an example, but if you deliver 20 windows to Norway, do you really need a contract with the builder who says that you need to do this reporting? What is important for you is that there might be clauses in the contract that requires you to pay damages or something like that. So that is why it's important to see, is this really something that should be applied to me, and what are the consequences if it is applied to me?
And often the contract itself doesn't say comply with Transparency Act, so you have to look for regulations that involve human rights, and the human rights clause is often now related to this type of due diligence assessment. So if it doesn't say Transparency Act, it doesn't mean it's not there, so you have to look a bit closely related to points related to human rights and the possible risks of breach. This is what the statement must include. I will not go through all of these points, but here you see it's a general description, and you have to use the assessments to fulfill the statement demands.
Yeah, that's the disclosures part. This is the part where the people, as I said earlier, the general public can simply ask questions and require information. So, and you have to provide the information in writing in a comprehensive and understandable manner, but there is an exception if it's obviously unreasonable, or if it's trade secret, etc., etc. But the basic rule is that you have to comply if someone sends you a request for disclosure.
And to the practical part of the webinar, what should the businesses do now? Yeah, you should carry out due diligence in order to answer questions. But as Petter said, you should start. You don't have to do everything at once, but do a risk assessment on where or which of your contractual parties or suppliers there are the biggest potential of breach. Map your business supply chain and business partner and consider the potential risk and decide where to start. You don't have to start with everything at once, but do an assessment.
If you, for instance, receive materials from mining in an area of the world where working conditions are relatively poor, then perhaps that is where you should start.
Yeah. And as Petter said, review your internal policies and contracts and consider, do you have internal expertise to carry out the requirements in the Transparency Act? Is employee training required? Do you have to hire someone with skills, or do you collect external assistance? As we said, many businesses have already taken steps to comply as a result of voluntary reporting and certification schemes. You should also check if you are one of these companies, what do I have and what do I miss to be compliant? As Petter said, the Norwegian building products manufacturers are probably already well on their way and complying with the requirements of the Act, but you then have to collect the information and put it in the report that the Transparency Act require you to. And it's also important to review existing documents to identify and supplement if necessary. There is also similar legislation on the way in the EU. Norway is in the front of this work. But Germany has also passed a law with several similarities, and Finland and Netherlands are doing the same. There is also a EU Sustainable Corporate Governance Initiative who has several similarities. And all of these are related to human and labor rights.
As you can see already, what we said about having a competitive edge, if you do business with Norway and you start adapting to these rules when they are implemented, because it's when across the EU, then you will already be ahead of all your competitors, I would dare to say. So this is something that could bring extra money and bring extra competitive edge into your businesses.
You can also see, related to EU legislation, that the EU taxonomy also has a side to these social and human rights regulations.
Well, thank you.
Thank you.
That's what we had, but we are of course available for questions if we have the time. Yeah.
Thank you so much, Petter and Tine. This was very informative. As said, there is an opportunity for you to ask, for the participants to ask questions. So feel free to post them in the chat or raise your hand. I would have, before there appear other questions, I would have a question about this definition of fair wages. What is where to look up the standard in different sectors in Norway so that Latvian companies would know?
I think we are at this point in a situation where we have lack of practice. So as Petter said, it will be branche.
As it would be, yeah, but industry specific. I would say that if you have guidances, you already have agreements with unions, you have salary charts. So I would think that if you are in line with what the serious actors in the business are doing and pay those wages, you are within the range of fair wages. I understand that is not really concrete because I don't have the numbers in my head, but what you could do is that you would contact the Norwegian unions or Norwegian Union or the NHO, which organizes the employers. We could help you with that, and you could get specific numbers and specific details which would help you if you are searching for information like that.
Okay, so we have 2 questions, and I'll quickly bring them up and give Pål a heads up that Pål, you'll be up next. But I'll ask the questions. How far the law determines the impact of the value chain regarding suppliers? So, like, how many steps? And I'll also throw in the other question: where should the reporting be done? Is it enough just to post it on the homepage?
Yeah, the law says all of the supply chain, even down to the buttons on the work pants that you wear on the construction site. But I think the same goes for this topic. Start with the biggest risk ones, because the practice from the Norwegian
watchdog,
yeah, is not clear. Where do we stop and where do we start? We don't know yet. But you don't have to start with your entire supply chain at this point, based on our assessments, but you have to start where the risk is highest.
But this shows why all the companies would include this in their contracts, even though the sub-supplier is not directly covered by the Act. Because if one of the large Norwegian construction companies, want to comply, then they have to put all these obligations all the way down to their suppliers, so that the producer of the buttons will have to report up, so they don't get to do all that work themselves. That was the second question as well.
The second question was about where do you send the report? You don't send the report, you publish it on your website. And Forbrukertilsynet, the watchdog, say that they will do checkups randomly, but how and how many, and we don't know yet. But I know that they have hired 19 lawyers to follow up on the Transparency Act going forward. So they are ready to make sure that at least Norwegian businesses are compliant and doing the work needed to be compliant.
Practically speaking, I think the most important aspect of your reporting will be when you are contracting with someone. They will ask you for that.
I think the same as you, Petter.
Thanks a lot for the comments. So let's bring also a perspective from the public affairs perspective. So Pål, are you there?
Indeed. Thank you very much, Else, for inviting me to join this this panel. I'm gonna just put up. I have a very brief presentation here. It's just a few slides. I assume you can see our logo. So why am I here? I have a background serving as foreign policy advisor in Parliament for some 7 years, and one of the key white papers that we were responsible for was the white paper on CSR back in 2009. So basically, when Codex is saying that this is a new law, that is correct, but this is a culmination of a development that has been taking place in not only Europe but the rest of Europe for some 10-15 years. I was also, back in 2013, I was Deputy Foreign Minister responsible for also CSR, and one of the first issues that I dealt with was the POSCO incident, where the Norwegian Sovereign Wealth Fund had invested in a supply chain in India, where claims was that the steel power plant was breaching basic labor rights and human rights. So that was a case that attracted quite a lot of attention. I also have a background as a fellow in United States Congress, where I particularly worked on human trafficking. And I'm currently a partner and senior consultant in Rud Pedersen Group, with offices in Oslo and 12 other countries across Europe. So my colleagues from Codex have gone through in detail some of the important aspects on the Transparency Act. It was actually debated in Parliament on the 9th of June and passed officially on the 18th, just before Parliament left for summer recess. But again, this was work that was initiated by the previous government, so the government of Erna Solberg, and as has been deliberated on earlier, the requirements is to publish due diligence assessments on human rights, decent working conditions. There was actually some discussions in Parliament also on the difference between decent work and decent working conditions. So you see here that there are quite a bit to read in between the lines on how this law came about. I also just initially wanted to draw upon the debate that took place in Parliament in June, and three key aspects that were discussed but were not actually put into the final law. So there were, both in the public consultation process and also among some of the political parties, there was a desire also to include a clause on transparency on place of production in the Act. And I'm not going to say too much about that, but we've had a case now with a big bus procurement in Oslo. This started basically basically last year, where Unibus, the partly publicly owned bus company in Norway, was considering acquiring Chinese electric buses. And this led to some internal discussions. Some is public, some is not public. And then they decided to scrap acquiring these buses because they couldn't verify transparency in the procurement chain that would guarantee against human rights breaches, lack of certain labor standards, etc. And this year there was a big public procurement in Oslo East, also for buses with 3 of the competitors, and a big discussion in the city council on whether any of the 3 competitors would actually draw upon Chinese buses. So place of production was also heavily debated in Parliament. What we also see is that there were a number of groups that also demanded stronger wording on environment. So basically, the Transparency Act as such is dealing with human rights breaches and working conditions, while the larger OECD guidelines of multinational enterprise also has clauses on environment, etc. And where this POSCO case back in India that I mentioned in 2013 was a classical example of that. And I know, and you know that majority of companies in Norway are, at least internationally, considered small and medium-sized enterprises. And of course, there is a difference between whether you're talking about a company of a turnover of 70 million and a company of a turnover of 7 million. So a company or an SME with a turnover of 7 million might not have the same capacity on reporting and fulfilling and being able to answer transparency requests, etc., compared to some of the bigger companies. So the discussions in Parliament were also that should there be more involvement of the SMEs, basically. So this is a hot topic, and it will be there will be a review of the law later. So this topic is not that. As I said, some key considerations. This is a culmination of a long development where previously soft law now has become more or less legalized. There was an evaluation, a report by KPMG that assessed that the first year, the overall cost for businesses being in line with the Transparency Act would be some 700 million NOK, around 70 million euros. We see developments in parallel in a number of Norwegian cities. There is an Oslo model that has been on the table for quite some years. The government is now also discussing a national model, which would kind of mirror the Oslo model for labor standards, workers' rights, etc. This is not an easy area, as seen by even the Prime Minister's office and the Directorate of Taxes, where we've had situations, unfortunate situations, where there has come up in the day that there have been breaches in the supply chain related to worker standards, safety, etc. One additional key aspect is, of course, the watchdog, the consumer authority, when they will react to breaches and when they will not. So, of course, where they set the bar is also a hot political topic. So, also on the one side, you have the legal aspects, what you have to do, but there are also key reputational aspects. So you might actually be transparent. You might fulfill requirements, but you still might have a reputational challenge if you are named and shamed. We have cases also with, unfortunately, with Latvian companies in Norway where this has been the case. So in the wider context, of course, the watchdogs, the journalists, the NGOs, etc., are standing ready, basically, to file questions to many of the companies that will have to answer for the Transparency Act. And about which sectors which will become important. So on the one side, construction sector, definitely. We see also, I'm heading our transport and infrastructure team. We see a big debate on minerals now, which of course is relevant to everything from electric vehicles to micromobility to batteries, etc. And my last point is basically a lot of the challenges that we advise foreign companies on in Norway is that what they do in Colombia, what they do in DRC, Congo, what they do in South Africa, quite often in Norway becomes a local or a national issue here. We see that with the Chinese EVs, we see that with the POSCO case, and we see that in a number of other cases as well. So this is our current map of the markets that we cover. So we work with a number of both small and medium-sized Norwegian enterprise to big global companies in a number of different sectors. So happy to answer any questions that you might have.
Thank you, Pål. So yes, we also try to be compliant with the time that we've set ourselves, but as we started a few minutes late, so let's give an opportunity for a round of questions if there are. And I see that there is a question, the name of watchdog organization. If somebody of the Norwegians could please post it in the chat section so we know how to look it up. I have a question. You addressed the question of non-compliance, how much it could cost. Do you have an assessment how much the compliance could cost? Like what resources do you think the companies may have to invest in order to be able to carry on their contracts? So can we start with Petter or Pål, you want to take first?
I think of course that depends on the size of the company, depends on the complexity of the supply chain, and probably also sector. What we see from the KPMG report, they're saying the overall costs for Norwegian businesses would be around 700 million NOK the first year, and goes down to around 630, if I'm not mistaken, the second year. So we are talking about considerable cost, and I don't have the data on how these costs are divided by company.
Petter, Tine, do you have any additional comment?
Well, I think Pål Arne answered brilliantly. We agree, and as we said, we think that as you come into it and you have some practice, you see how the Forbrukertilsynet, the watchdog, acts, then you will perhaps see a leveling out of the costs because you have something to adapt to. But I think it's hard to predict, and I think the answer from Pål Arne was really a full and good answer.
So yes, last call for questions from the participants. And in the meantime, I will throw in my own. So you talked of the impact on the market. What is your assessment? Do you predict that quite a few companies who have made until recently been competitive price-wise, but not human conditions, working conditions-wise, do you think they will leave the market? And what could be the number of that?
This is what the vice mayor in Oslo is hoping, that it will, commenting on the Oslo model, which is of course also relevant for this. He was quoted just a few days ago that they are revising this so-called Oslo model, which is particularly relating to the construction sector. But he said that we are hoping that this revision and stricter regulations in this area will divide the serious players from the not so serious ones. So of course, for those that do not fulfill these requirements, they could potentially be name and shame. It could be fines, infringement, as Codex was elaborating on. And we see, I mean, I don't want to go into concrete Latvian cases, but we see the discussions with Latlaft and the stories in Aftenposten about labor standards, etc., has implications for companies, definitely. So, and we can only expect that also probably other Norwegian cities will follow up on this.
Thank you. And there's a question, will these costs include choosing more responsible contractors who are not dumping the price due to HR costs? I may have to clarify what these costs mean, but Petter, Pål, do you have a comment?
I think in general, and still we see that, and we deal quite a bit with companies in probably mainly defense, energy, health, and transport that are related, that are into public processes in Norway, procurements, etc. And we see still, I mean, cost is a very important factor in public tenders. What we see increasingly also, take one concrete example, micromobility, e-scooters, etc., where Norwegian municipalities and cities have started putting out tenders on the market. So the first year was a bit try and fail. Now we see that sustainability, tariffs, workers' rights, conditions, etc., are becoming more and more important in the tenders, and they also, the ratio, the percentage of the importance in the tender is also increasing. So my assessment is that cost will of course still continue to be the key aspect, but these issues are coming more and more up on the agenda.
Okay, so thank you, Pål. So we run a few minutes past the time. I will now thank Petter, Tine, Pål. You've been very informative on what's up and coming. With your permission, we'll share the presentations. And yes, thanks to the partners, Latvian Wood Construction Cluster, for joining the participating in organizing this, and especially yes to the speakers of the day. I have a brief survey, brief poll to all the participants who stayed until then. It's just one question, if you agree to evaluate the webinar, so we know to adjust how we operate in the future. But I would wish you all a good day and keep your heads cool. We need that right now.
All the best.
Thank you so much. And yes, if you're welcome to provide a feedback. Thank you all.